I'll tell you what it means to the people at home, that this is like a lesson in constitutional law. The hearing just ended less than a half an hour ago. The judge wants to get through this hearing because he understands that this is a very important hearing and there's a timeline. And in fact, what he did to put a hold on that 1931 law, he did put a hold on it, but only until the end of this hearing. Now, let me tell you what's going on. The big issue in the case, I'm going to try to generalize it, is there a right to an abortion in Michigan? That's what this hearing is kind of going to say. The governor, who's suing some county prosecutors, says, yes, there is a constitutional right under Michigan's constitution to have an abortion. She also says that the 1931 law that was passed by the legislature 90 years ago is bad law. And it was bad law in part because that law back in 1931 was made to keep women at home having babies. If you can believe that. That was the argument in the court today. Now, the attorney, David Coleman, he's representing a number of prosecutors. He says there is no right to an abortion. That right may have been in federal law under Roe versus Wade, but the U.S. Supreme Court said no to Roe versus Wade. But what he did, he said this whole issue has already been decided, like in Dr. Kevorkian's case, where Dr. Kevorkian wanted to end a life, assisted suicide, and the court said, no, you can't do that. He's trying to say that you should not be able to end a life before it's born. A lot of various arguments going back and forth. I got a chance to talk to a couple of people that are talking about these particular issues. Take a look. Do you think this law was made to keep women at home and having babies?
In fact, that is what the history shows. In the 19th century, there was a movement against women's increasing participation in civic life and political life, and the anti-abortion movement sprung out of that to try to return women to what was seen as their rightful place as mothers. So these two are intertwined.
Well, that's silly. We have all kinds of laws on the books that are from 100 years ago, 150 years ago. They're not invalid just because they're old. That's a silly argument.
You say, Dr. Kevorkian, that this case somehow it's already been tried, and the decision in Dr. Kevorkian, which says you can't have assisted suicide, should apply here.
Right, but well, it's the argument. They're making the argument for bodily integrity, that's a new argument under the Constitution that means there's a right to abortion. The Kevorkian case says no, and that's why I argued that because they said it's not, you don't have the right to end a life. I mean, that's what Dr. Kevorkian was arguing. And he argued it based on bodily integrity. I have the right to end a life. Now, it was a life at the end of life, somebody who wanted to end their life. But why is that any different? Why would it be applied any differently to the beginning of life?
I guess the judge is going to have to decide what applies. Now, I can get to the real constitutional issues, but we'll see what the judge does. Now, by the way, a couple of doctors testified today. We found out that based on statistics, 90% of abortions occur within the first 12 weeks, most by African-American women, and that they generally, African-American women now, don't have good reproductive health care, and that pregnancies are more dangerous than abortions. This is the governor's case, putting it on to saying that the law in 1931 is archaic. It doesn't apply now, and it treats people differently, African-American people differently, equal protection law, if you want to go back to the constitutional law books. Anyway, we will be back here for 3 more witnesses starting tomorrow at 9:30 in the morning. This case is far from over. Very interesting arguments. I'll send it back to you guys in the station there.
Yeah, so Charlie, timing is everything here. They keep seeming to push the can down the road. Now this comes at a crossroads where the judge said, extend it, but voters will likely be able to vote on this abortion issue before that in November.
Well, I think that there is a movement on both sides. There's going to be a challenge to petition signatures. Listen, the Supreme Court of the United States said it's probably a states' rights issue. Some states have the death penalty. Some states legalize marijuana. Some states will have abortion. Some states will not. And I think it's probably going to end up that way. However, this one now is that there's a lot of uncertainty in the law. Can you have an abortion? Will a doctor go to jail or prison? Because that's really what this case of the statute is about. It's a criminal statute. If a doctor performs an abortion, he or she goes to jail. So we need certainty in the law. We don't like this uncertainty, and that's what's going on right now. So the judge has to make a decision one way or another. Do we have an abortion? Can you get an abortion or not? And that's what the judge will decide. However, this could all be undone in November when maybe all of us, all of the voters will vote, assuming that can get on the ballot, and there'll be multiple challenges to that. We're not done with this for a while.
Yeah, already more than 750,000 signatures on that petition to try to get it on the ballot. We'll see what happens. But Charlie, we know you'll be on top of it. Thank you.